lawyers in advancing the rights of sexual minorities. And I'm also going to spend just a couple of minutes talking about a couple of important precedents in the arena of international law at the UN level, that is the truly international level beyond Europe. Well, first of all, with respect to the role of lawyers, I have to obviously concede some bias because I am a lawyer myself, but speaking from my perspective as a Canadian lawyer, I can tell you that many of the advances in my country have come as the result of hard work by lawyers representing individuals and NGOs who are willing to tackle governments. And I want to acknowledge that before he assumed his august position as a judge of the Superior Court, that my good friend David Corbett was one of those lawyers who was well known in my country for advocating for vigorously and successfully for the rights of sexual minorities. It is clear that law has an interactive relationship with social attitudes. In Canada, certainly, after decriminalization, which was clearly something that was initiated by government, I think it's fair to say that the vast majority of legal changes were made in the courts. Social attitudes followed those legal changes. They were influenced by those legal changes because people pay attention to such court cases. Certainly, I think in most countries, they tend to attract a great deal of publicity and stimulate social discussion. And it was the experience in my country, and I think in some others, that the politicians tended to follow after the court rulings took place. I think many times what we have experienced is that you have to overcome hostile politicians in the courts, and sometimes even friendly politicians find it difficult to enact controversial measures without the comfort of being able to point to a court decision that says this is something that is required by national or international law. I should also say, though, of course, that lawyers can play a role as setting an example in society. In my country, in Ontario, some years ago, the head of our bar, we call it the Law Society, decided that he had to do something about discrimination in the legal profession itself. And he made a point of holding a reception at the headquarters of our bar in Toronto, to which he invited all of the bar leaders, the judges, and members of the LGBT community to celebrate our annual Pride event. It was a very brave and bold act on his part, and it has now become a very well-known annual event, and indeed straight people and members of sexual minorities join together to celebrate the progress on equality, and it's something that has really set a tone within the legal profession in my country. Before I turn to the legal precedents from the international arena I want to mention, I think one thing that we also should recognize is that the interest in comparative constitutional law in all national courts has grown enormously over the years. The Canadian court, for example, will often consider decisions made in other jurisdictions, particularly depending on the issue, looking at the jurisdictions, for example, on human rights issues. Decisions of the European Court of Human Rights are frequently cited. We're also interested in what happens in the Constitutional Court of South Africa because they have a similar constitution. There is a great interest in and particularly in the area of protection of sexual minorities. You can scarcely read any decision from any court considering the rights of sexual minorities that does not involve some consideration of precedents from other jurisdictions. Indeed, we in Canada take great pride when we see decisions of Canadian courts being cited in South Africa and in the American courts. And one must not, I don't think, overlook the fact that this type of judicial education process and the opportunity for interaction between the judges of different international courts is also a very important impact and an informal and perhaps slightly invisible way on sharing ideas and improving attitudes towards sexual minorities. Well, now, having talked about those kind of large concepts, allow me to turn now to a few points of jurisprudence. And I'm going to talk about two cases in some detail and one very briefly. They all are decisions that emanated from an entirely different part of the world, from the far reaches of the South Pacific. But they are decisions of the United Nations Human Rights Committee, considering the International Covenant on Civil and Political Rights that Boris mentioned in his introductory remarks. And I think they're very important in understanding the requirements of international law. The cases I'm going to talk about are the Tunin case, the Young case, and the Jocelyn case. The Tunin case is very important. Australia, which was the responding country to that complaint, ratified the ICCPR in 1980, and it acceded to the first optional protocol which allowed Australians to take complaints to the UN Human Rights Committee in 1990. And interestingly, the very first complaint taken by an Australian to the UN Human Rights Committee was one involving the rights of sexual minorities. And it was taken by Nick Tunin, who was a resident of the state of Tasmania. Australia, as I'm sure many of you know, is a federal jurisdiction, and the criminal law is under the control of the state governments. And Tasmania was one of the last governments in Australia that still criminalized sodomy. So Tunin sent a communication to the Human Rights, a complaint to the Human Rights Committee in 1991, complaining that this law of Tasmania was a violation of his right to privacy under Article 17 of the ICCPR, and that it was a violation of his right to equal treatment under Article 26 of the ICCPR. And one of the things that was very important about the Tunin decision was, up until this time, of course, the ICCPR does not mention sexual orientation expressly, and one of the issues that the Human Rights Committee was called upon to decide in that case was whether or not sexual orientation discrimination was covered by the treaty. In the result, the committee found that adult consensual sexual activity in private is covered by the concept of privacy, and that Tunin was affected by the existence of the Tasmanian laws, which continuously and directly interfered with his privacy, despite the fact that Australia pointed out there had been a lack of recent enforcement. They also rejected an argument that the laws were justified based on the need to prevent the spread of AIDS. The court found that the sections did not meet the reasonableness test in the circumstances of the case, and that they arbitrarily interfered with Tunin's rights under Article 17, paragraph 1. The committee also found that with respect to the question of whether sexual orientation could be considered another status for the purposes of Article 26, that the reference to sex in Article 26 was to be taken to include sexual orientation, and that precedent has been followed ever since by the UN Human Rights Committee. It is interesting in the result that the Tasmanian Parliament refused to respond to the UN Human Rights ruling, and the Commonwealth government eventually, after a further lawsuit was brought in the domestic courts of Australia, responded by using its authority under the Australian Constitution to overturn the Tasmanian law in order to ensure that Australia was complying with its obligations under international law. The second case I'm going to mention also involved Australia. It's the Young case, and this case is a more recent one, communication from 2003. And in this case, Mr. Young was in a very long-term relationship with a war veteran. When his partner died, he sought a pension survivor's pension under the veterans legislation in Australia, and it was denied to him on the basis that he was not in an opposite-sex relationship. And the legislation was very clear that unmarried partners were entitled to the pension, but they had to be of the opposite sex. He had been unsuccessful in the Australian courts and administrative tribunals in challenging this provision. Australia, unlike Canada, does not have a constitutional Bill of Rights, and so Mr. Young took his complaint to the UN Human Rights Committee. The Human Rights Committee noted its previous jurisprudence that including Tunin, that said that discrimination under Article 26 includes discrimination based on sexual orientation. It also noted that it had in previous communications decided that in some circumstances offering different benefits to married and unmarried couples could be found to be reasonable on the theory that the couple could choose whether to marry or not. And they noted that in this case, that as an Australian, Mr. Young was unable to enter into marriage with his partner, and therefore in the circumstances of this particular case, they were unpersuaded by the arguments advanced by Australia that there was any reasonable basis for denying the pension to Mr. Young, and found that his right to equal treatment under the law, under Article 26 of the Covenant, had been violated, and called upon Australia to repeal that legislation. Interestingly, unlike in the Tunin case, in this case the government of Australia, which was then led by Prime Minister Howard, was reluctant to accept the UN Human Rights Committee ruling and initially refused to change the law. However, I'm pleased to say that after the election of Prime Minister Rudd, the Australian government took steps to change all of their laws to include protection for de facto same-sex couples. So the spirit of the Young ruling, which is that unmarried same-sex couples are entitled to the same rights under the law as unmarried opposite-sex couples, is now being respected in Australia. And I may say it is a principle that really needs to be respected in all countries, and I think all of the lawyers and judges in this room who are familiar with the laws of Montenegro will recognize that there is a great deal of reform that's going to be necessary in this country to bring Montenegro's laws into compliance with the ICCPR, to which Montenegro is a party, of course. The final case I'll mention just briefly is the case of Jocelyn in New Zealand. We hear a lot from the opponents of the rights of sexual minorities that the real agenda is same-sex marriage and everything will inevitably lead to same-sex marriage. It is very clear from the Jocelyn case that went to the UN Human Rights Committee that there is currently no requirement under international law to offer same-sex marriage to the citizens of Montenegro. It's certainly not required by the ICCPR. However, it is permitted. So it will be a choice for Montenegro to make one day. But what is clear is that the rights of same-sex couples must be recognized, at least to the extent of offering the same benefits. So in conclusion, I will say that I think it is clear from the UN rulings that there is a protection against discrimination that is a fundamental principle of the UN Human Rights Committee jurisprudence, and that extends to recognizing the rights of same-sex couples to equal treatment. I think we have some way to go in this country to promote the rights of sexual minorities, and that I hope that lawyers in Montenegro, along with the judges and other members of society, will play their part in advancing the rights of sexual minorities. Thank you.